Good morning. My name is Haesun Kim, advisor of Gangnam Labor Law Firm. Today with Labor attorney Jung Bong-soo, we will cover a story that was published by Mail Labor News. Today's article, which is regarding whether the trainee who was during the training session was dismissed, and whether this trainee should be considered as a labor employee or not. So could you explain the background story, please?
Hello, how are you today? This is Bong-soo Jung, Korean labor attorney. This is a case related to the dismissal of the trainee. Job applicant applied for a job in the international company. So this company reviewed his the application and accepted, and also this company examined the employee's ability for English. Then also this company accepted this employee as a job candidate. Then the company asked him to sign. There will be 1 week training. So when you pass this requirement in this training, then you will be hired as an employee. But if you failed, then we cannot hire you. So this company explained to him, and the job applicant signed the contract. Then this employee trainee worked, maybe attended that training course for 1 week. Then after 1 week, his score was not appropriate, not enough to be accepted as employee. So the company informed him about his termination. Then this employee claimed it is unfair dismissal, and the Labor Commission judged this case, and they concluded the company informed this employee verbally, not by written the statement. So this is unfair dismissal, they concluded. So I think this is a very simple case. So they judged based on whether this trainee is employee or just a non-employee. So in this case, the Labor Commission concluded this trainee belonged to employee status, because it is first to attend. Without attending, employee cannot get a job. So the trainee should be regarded as employee. Then, to dismiss the employee, the written notification is required according to the Article 27 of the Labor Standards Act. So company neglect to inform in writing, but just inform verbally. So they concluded it is unfair dismissal.
I see. So this is so without the written dismissal agreement, so the Labor Commission has made a result that this is an employee, although he did or she did not make a score that they had expected. Is that right?
Yeah, that's right. So if the company issued the written notification for termination, then what will be like? I think what if company issued such a written termination? So it can be then issue like a training period is a kind of probationary period. So it depends on what the types of the education was provided. Also, how the test is paired. Yeah. So I think such a training period can be regarded as probationary period. So then if a company issued a written notification for termination, then I think the Labor Commission may have some more consideration for this case. So yeah.
So in order to justify the the dismissal, the company should have given should have included him as in the training program before signing any employment agreement. Is that right?
Yeah.
Test his ability before signing any agreement with the trainee.
Actually, this trainee didn't sign employment contract. They only signed. They just received some passing of the entry exam. So only here what they sign is this training course. So they claim that their status is not employed. They are only trainee. So the employee cannot pass this training course. Then company have authority to terminate this relation. So then the employee signed. So here, so company regarded this trainee as not employee, but labor commission treated this trainee as an employee because this the mandatory training. Also, employee has to follow all required the orders there. Yeah. So it is like a probation period. So main issue is it was concluded very simply. So labor commission treated this trainee as employee. Then to dismiss employee, the written statement of termination is required, but company neglect to follow it. That is the labor commission's decision. So here, what we need to consider is what about if company issued a written notification for termination, then company may consider whether this the termination is justifiable or not. So the training course is more than job required, then it can be like unfair dismissal. But this basic course, to be qualified for this getting job process, then I think it can be considered differently. So I think this case is concluded in the middle of the actual case. But if the employee was dismissed with a written notification, then there will be a lot of things we have to, maybe as a labor attorney, we may consider. Yeah.
I see. Then if this trainee is considered as an employee, then he should be employed by the company.
Yeah.
And in such case, the employer and the employee relationship may not be very smooth because of the situation.
Yeah, yes. Then probably in this case, then the verdict content is like company. I mean the company's the termination is unfair. So company should reinstate him and also pay back pay during the dismiss period. This is an order from Labor Commission. So company should reinstate this employee and pay back pay. Then what will be like? Then I think a company may consider some assign him for training again, and if employee this trainee pass the required course, then the employee will get the job. But if the employee repeatedly failed that training course, then it will be justifiable for the company to terminate this employee again. But it must be issued with a written notification.
I see. And I understand you have a similar experience in the past with a language teacher.
Yeah.
Could you introduce whether it's a similar situation or very different?
Yeah, I think this is a very similar case. So an Australian who want to be an English teacher at one of the very famous language schools here. So that he through many review process, he passed such a exam, and he came to the Korea and attended the training course. So unlike his expectation, he wanted to get a job, but company asked him to become the high level English teacher. So, but the this employee could not get such a higher course as a maybe trained teacher. So he was qualified with intermediate the teaching instructor, not the high advanced level. So company just terminate this employee, of course with a little notification. So I think I thought at that time it was unfair dismissal, because company employer only when he was hired, he just informed he'll become a teacher, not advanced teacher, so advanced level teacher. So I think it was unfair. I thought, but this employee could not afford to appeal to the National Labor Commission, because she must spend a lot of money, and so at the time I think he returned to his home country immediately, because he could not afford to stay. So it was a very sorry case. I represented this employee.
So it's like a similar decision like a labor commission
Yeah,
today.
So,
that you gave proper advice, but it was an unfortunate case.
I don't know why Labor Commission decided very negatively for this employee, but I think I thought it was unfair judgment. So I suggest the employee we should go to the appeal court, like appeal commission, to the National Labor Commission, but employee could not afford to apply because he didn't have any money. So it was the case I felt very sorry about.
I see.
Yeah.
Thank you very much for your comment.
Okay, thank you for watching. Okay, bye bye.